I think the panelists did wonderfully well and gave us so much good information, and you will have time to sneak in a few more vital points as the panelists present their views and their questions to you. So now we're going to have the first round of discussion, and each of the panelists will have about 7 minutes to interact with the first three presenters. So I'll begin with Peter, if you will, and the microphone is yours.
There's been some discussion of this, but I thought I'd like to hear from you, just so you know that one of the most controversial provisions in the bill is that after your last decision, whether that's a decision from the Refugee Protection Division or from the Refugee Appeal Division, after that there is a bar for 1 year where you cannot apply to remain in Canada for humanitarian and compassionate reasons, and you cannot apply for a pre-removal risk assessment. And I wonder if any of the contributors could speak to that issue.
Thank you very much, Peter. Yeah, the denial of access to a pre-removal risk assessment prior to deportation, I think, is a fundamental problem with this bill. Under the Charter, under international law, and pursuant to the decision of the Supreme Court in Suresh, there needs to be an assessment of any risk claimed by someone who's about to be deported prior to that deportation actually happening. We've had a PRA in the law for a good long time now. It's had different names over the years. But this idea, I think, is fundamentally against the Charter. I think it will be challenged quickly and hopefully successfully quickly in the courts. I am certainly hopeful that with enough noise they will at least drop that one. It seems like a bit of a no-brainer from my perspective.
That's a technical legal term, no-brainer.
Right.
Only the lawyers will understand that. I've now got a general question for all of you, and this is intended to be somewhat of a tough question. Most of you have mainly spoken about fairness and the lack of fairness in the bill, and there are some clear areas where there is a lack of fairness. Andrew spoke first of all about in the beginning that there just isn't enough time to present and prepare the case. There are some concerns about, we already talked about the lack of an ability to apply for humanitarian compassionate grounds afterwards, and of course the safe country of origin list. However, the minister's made it clear, we all know that right now it's an average somewhere between 4 and 6 years to fully decide a negative refugee claim and remove the person. Most people agree that that's too long. Slow decision making doesn't help refugees either. So can you give me some suggestions on how you would actually speed up the refugee process?
I think to begin with, I'm not convinced that new legislation such as this is absolutely essential to speed up refugee process. There isn't anything in the current bill that would prohibit the ability to have refugee hearings at the upfront stage in a more timely manner. The timelines that the minister has announced in this bill are all things that are left to regulations. So even there's some opportunities for things to take longer than what the bill is or the minister is suggesting at this time. So I think we can't be absolutely certain that the revisions that he's proposing are in fact going to accomplish what he says, or even that the bill is necessary in order to accomplish that, and that the same processes could not be dealt with adequately in the bill as we currently have it. I think the question of resources is one that Andrew has already mentioned, and the minister in providing this bill has acknowledged the fact that there do need to be adequate resources at the front end of the refugee system. I would say that the bulk of the problems that we have in refugee determination today, in fact, are not at the front end of the system, but rather at the back end of the system. And while there are delays in getting access to the refugee hearing, and Andrew referred to somebody that had waited up to 3 years, that's the exception, not the rule. About a year is typical. But actually where the real backlog is taking place is after the fact. It's after a negative decision from the Immigration and Refugee Board. When the decision making at that point goes out of the control of the Immigration and Refugee Board and into the hands of the bureaucracy, where decisions are made on pre-removal risk assessment or humanitarian and compassionate applications. And that's where the process grinds to a halt. And I'm not sure that this bill does anything to adequately address that, other than suggest that people are going to be removed more quickly, but without providing any guarantees that those that are removed more quickly are not going to be removed to situations where they may face persecution.
Unfortunately, you haven't answered my question. Other than resources, I'm asking if you can propose some amendments to the current system that will actually be fair and at the same time speed up the system.
Yeah, well, I have one thought. Well, hopefully more than one, but in answer to the question, right now, of course, there's a great deal of concern from the minister apparently regarding humanitarian and compassionate applications delaying proceedings. One idea that has been floated is that when someone is before the IRB explaining why they're at risk, right now, if they're refused, they after that usually need to file a humanitarian application asking for consideration on the basis of other issues like the best interest of the child, for example, or extreme hardship that might not meet the definition of persecution, asking for consideration of those issues. Rather than having that a completely separate process after refusal by the IRB, why not give the IRB concurrent jurisdiction? Why not let the IRB look first at the refugee claim, see whether there's a risk of persecution? If not, then consider whether there's a child whose best interests require that the person be granted the status here. Look at other kinds of hardships, generalized violence. Why not give that to the IRB? It would be a whole lot faster than the current process. The person's already at the IRB. I think that's one way to dramatically speed up the process and bring some more fairness into the process.
Okay, thank you.